All right. Please be seated.
Good morning. Welcome back to a morning session for the Sixth District Court of Appeal. We have one case remaining this morning. It's Morabel versus the State of Florida. My name is Judge Nardella. I'm joined today by Judge Ganem and Judge Mize. The appellant has 20 minutes, as does the appellee. We typically reserve 5 minutes for rebuttal, but if you would like a different increment of time, please let us know. Counsel for 5, okay. Your argument today will be broadcast. And with that, whenever you're ready, you may begin.
May it please the court. Counsel.
Spencer Cordell on behalf of Vladimir Morabel. We are asking the court to send this back for resentencing. The plea is going to stand, but at his sentencing hearing, he was not able to fully present all of the mitigation evidence that he wished to present prior to the court issuing sentence. I'd like to point out to the court today that the trial court initially at sentencing, I think, got kind of caught up in the fact that his substantial assistance, which we were presenting for mitigation, once it was determined that the court couldn't go below the mandatory minimum sentence because the state hadn't filed their motion for substantial assistance, that the court said, I don't need to consider substantial assistance. Forgetting the fact that there were two purposes for it. One, if there was a substantial assistance motion, then the court could have gone below the mandatory minimum. But even without that motion, it was still evidence in mitigation. The substantial assistance, the 5 people that we proffered that he had given information to law enforcement for, that resulted in arrests, that resulted in prosecutions, was something that needs to be considered when the court is determining the appropriate sentence. And it's also important to note, the court didn't restrict itself to the mandatory minimum. The court actually went above the mandatory minimum, sentenced him to 30 years on the trafficking counts. So that mitigation evidence certainly would have been relevant as to whether or not he needed to be sentenced to more than the mandatory minimum.
Counsel, can you speak to us about whether or not the trial judge was fairly appraised of the argument you're making today when it comes to putting your counsel on the stand for that evidence?
He was fully appraised that we intended to put that evidence on. And I was the trial counsel on this one. He asked me a specific question. Is there any way I can go below the mandatory minimum? Is there any way I can consider this when the state hasn't filed the motion? And my answer would still be no. You can't go below the mandatory minimum. And after that point, the judge didn't allow me any additional explanation. He actually said, I can't consider it, or something. It is something I cannot consider unless and that was on page 47 of the sentencing transcript. And then a page later, he said, it's something I can't even consider unless I have a movement from the state. And we said, we still think it's relevant, Judge. And that's the question on whether or not something can and must be heard by a sentencing court, is whether or not it's relevant. All right. The issue was, I did want to talk about preservation, as that was brought up in our request for additional briefing on the matter. The issue was clearly preserved. There was no objection because it was something that we were trying to introduce. I think we laid a pretty clear record of what we were trying to do. We got a clear ruling from the judge that it was not admissible. There was nothing for us to object to. There's no talismanic or magic words to preserve a record. I don't think we would have had to proffer that evidence because we'd gotten a clear, we had indicated specifically to the court what we wanted to introduce. We said, we've got 5 names of people that were arrested based on his information that we want to present to the court. And he clearly ruled that we weren't able to present it, but we did proffer it. In an abundance of caution, we said, these are the things that we would have said to the court. And he's entitled to be fully heard. And I think the case that's really on point on this is the Hodier'n case that I cited in my brief. That's the one where the individual had written out his statement. And the court cut him off in the middle of his statement and said, I've heard enough. He took the statement, put it in evidence, but didn't review the entirety of the statement. And he went ahead and ruled right then. And that's really akin to what we have in this case, that a defendant has to be able to fully present their argument, their statement, their evidence prior to sentencing.
But I wanted to ask, at some point during the hearing, as I read the transcript, it became clear that the judge was focused on this this testimony from your client as being relevant to the issue of substantial assistance for the purpose of a potential downward departure. At some point, did you need to tell the judge it's also relevant for mitigation in general, wholly, separate from the possibility of a substantial assistance downward departure? I understand you're saying it was relevant for that point. But did you need to tell the judge that specifically in order to preserve this argument here?
I don't believe so, because we made it clear what we were trying to do and made the specific point that the defendant is allowed to be entirely heard on the matter. And to be clear, the judge had ruled on it. And I guess I should point out, I think the judge got a little put out with the defendant because, and it's not clear in the transcript, it's not overt. When he says, I'm going to stop you right there. We're not going to do that. We're not going to put the prosecutor on the spot. So the judge got kind of caught up in that, and the defendant kept trying to talk, and the defendant's like, no, I'll give you one last word. And then he shut him down again. There wasn't an opportunity, again, with something that we're trying to introduce. I don't get to say I object. The judge, without objection, sua sponte, said, I'm not hearing any more of this. And I said, well, we want to present it. That's preserving the record. This is what we want to preserve. The judge didn't entertain any evidence except on the issue, or any argument except on the issue of whether or not it was possible to go
So
below
you
the
think if the
mandatory.
judge says, I think I'm gonna stop you because I don't think it's relevant to A. And you think it's relevant to B, you don't have to tell the judge, it's relevant to B, can we keep going?
I think I have to say, I still want to present this because we're entitled to. I don't know if I said the magic word mitigation, but I wasn't given an opportunity. Like I said,
You weren't given an opportunity to say, Judge, may I be heard on this? I understand you don't think it's relevant to A, but it's relevant to B. You didn't have that opportunity? Did the judge say you as an attorney couldn't say that?
no, the judge didn't say, no, Mr. Cordell, I'm not going to hear that. I said, Judge, we believe he is entitled to be heard in full. These issues, his substantial
Sorry,
assistance.
so that's what I'm saying, the legal argument.
Right.
The legal argument that it was relevant to mitigation. I think he's saying you didn't say, right?
Right.
Okay.
And part of the challenge there is that it wasn't an objection. There wasn't a relevance objection that I had an opportunity to explain myself.
But it was a ruling in which you had the opportunity to be heard, right? The judge says, I'm excluding that because, or I'm going to cut you off because it's not relevant to A, right?
Yes.
I don't think you're disputing. You could have told the judge, it's relevant to B. I don't see anything in the transcript where you tried to do that. I said no.
I don't recall specifically trying to do that, but
Correct. That's my point.
Yeah,
You did not try. You made no attempt to do that, correct?
I did not specifically try to make that argument. I made clear what issue that we were trying to present to the court.
Correct. You made clear the evidence you wanted in. You did not make any attempt to give him the legal argument for why that evidence should come in.
No, and I would say I was not given the opportunity. I mean, theoretically,
Hold on. Why were you not given the opportunity?
because the court was very clear that we were moving on from the issue.
Did you make any requests to say, Judge, can I be heard? Or Judge, I need to tell you it's relevant to B. Is there anywhere in the transcript where you say make any attempt to be heard on it that the judge denied or said, no, I'm done. I'm not going to listen to that.
I specifically proffered what I wanted to introduce.
Counsel, hold on. So I'm asking about one thing, and I think you know that, and I think you just don't want to answer the question. And so you keep redirecting to something else, all right? So I'm asking you about the legal argument, and you're redirecting to, well, I told about the substance of what I wanted to put in. Those are two different things. So when I ask you about one, I'm going to ask you to answer that one and not try to shift to the other. Okay? The legal argument. Is there anywhere in there you made any attempt to make the argument? And if not, is there any indication that the judge didn't allow you to?
I did not attempt to make that legal argument. There's no specific indication, though, as I was trying to say, I did specifically proffer what I wanted to introduce, and he shut it down pretty quickly.
Did he shut down any attempt for you to make your legal argument as to why you should be able to put it in?
Not specifically.
Generally? I mean,
It-
so
it-
now did he, it's a yes or no question, counsel. If there is, I want a transcript cite. Is there a place where he denied you the ability to make your legal argument? If there is, give me a page number.
He made it clear that he was not hearing any more about it. I don't, there's not a specific site because I didn't say, Judge, it's relevant for this other reason. I said, we're entitled to be able to put this in.
Counsel, I want to move the page a little bit.
Okay.
Since we taken supplemental briefing in this case, the First District Court of Appeal, as counsel for the state has supplemented the record with, has issued Emerson versus State. I take it you have some criticism of that opinion, and if so, I'd like to hear it.
I don't think it accurately applies Jackson. I think that the Florida Supreme Court's in Jackson was pretty clear about if there's an error that happens after the plea and prior to sentencing, that there still has to be a method for appealing that. I think the dissent in Emerson made a really good point about the need for the integrity of the system, and there needs to be a method for appealing these kind of things. So I would argue that Jackson is controlling, and where Jackson says if there's an error in the process, and I would concede this is an error in the process, it's not an illegal sentence, that it should be appealable.
What is your take on the First DCA's position that you'd have a remedy under 3850?
I think that's contrary to Jackson. I think they might have maybe, I don't want to say maybe misread Jackson, but I think Jackson was pretty clear that since it's not an error, it's not appropriate for a post-conviction motion, but it is appropriate for appeal. I think that like I said, I mean, I don't know if it's called a conflict with Jackson, but I think Jackson was pretty clear about those things. So I was kind of, as you said, in disagreement with Emerson.
Counsel, the majority in Emerson decides that an error, a post plea error in the sentencing process is not appealable, whether preserved or not. Judge Tannenbaum disagrees and concludes that it is appealable if preserved, but he does agree to the extent that he doesn't believe the fundamental error review is available. What about that? Do you agree with Judge Tannenbaum, at least, that it has to be preserved to be appealable? Or do you believe fundamental error review is available for a sentencing process error post plea?
I believe that fundamental error should be reviewable post plea. And the other cases since before and since Jackson have always allowed this type of issue to be reviewable. All the ones that I've cited were all direct appellate reviews of this kind of situation, and it's not clear on most of them what the preservation was or whatever. They certainly seem to think that.
Counsel, with that
it is.
belief, how do you square State versus Dortch?
Which one's Dortch?
Dortch had to deal with competency questions and the requirement that they be preserved in the rule.
Dortch is a very specific fact pattern. They said, yes, you have to be competent. And that's the one that said, but there's no harm here because there had been an order that there had been an opinion that he had been found competent from a doctor, but it hadn't been addressed to the court. And so I think Dortch is very specific to that really unique fact pattern of him.
But Dortch found that there's no constitutional right to a fundamental error review. All right, so you've got a constitution providing, at least under the dissent's view in Emerson, the Constitution provides you with certain appellate rights. And one of those is the right to the review of a preserved error. You got George saying, you don't have the right to you don't have a constitutional right to appeal a fundamental error. And so then you have 924.051 saying you don't get to appeal an unpreserved error. Right, so take me through how you get to the process of you still get to appeal a non-fundamental error, or you still get a fundamental error review there.
I believe that except in the circumstances under Dorch, that a fundamental error is still appealable under Jackson.
So you've got George saying you don't have a constitutional right
Yeah,
to appeal a fundamental error, and then you've got a statute saying that when you plead guilty, right, you cannot appeal anything if not preserved, including fundamental errors. So tell me how you get there.
I get there because the other the statute that, and I hadn't prepared that specific issue. I did cite it in my supplemental brief that the statute that allows appeals, like subsection, I think it's E, specifically says others allowed by law. And as the dissent in Emerson says, constitutional issues are still allowed by law. I think,
But that's with the dissent. So you're right. So that's a rule. That's 9.140, 2AC2 or something.
Yeah.
And he said otherwise provided by law refers to, or at least encompasses, the Constitution, and the Constitution gives you a right to review of preserved errors. But then it said it does not give you a right to review of unpreserved errors, right? So that dissent in Emerson doesn't help you on the fundamental error question, because it specifically said.
oh, I didn't remember that part of it. And then obviously only just it just came out recently.
Okay.
Um,
It's a tough question. You've
Yeah,
got- you've got
it's-
two really brilliant people in the first DCA disagreeing on it, in my mind, so.
yeah, and
it's
you've
tough.
got, and I was, I don't know, my takeaway from that was the dissent saying, otherwise you've got a hole in the system where you can, like, things that happen, you're waiving your right to appeal things beforehand and not afterhand, but it's got to be preserved. But I believe our specific introduction of what we wanted to introduce preserves the issue. So I do think it's a preserved issue.
Okay, but we're kind of asking you if it's not.
I know, and I think under the Constitution, it still has to be, and I think that's the progeny out of Jackson, though I do disagree with the thinking in Emerson.
Okay, but do you acknowledge that the Supreme Court disagreed with you in Dorch, and that we're bound by that? I mean, Dorch was a 4-3 decision. I'm not saying your position is crazy, but it does seem to be completely and utterly foreclosed by binding authority. We can't adopt.
I'm not gonna,
We can't adopt Supreme Court. dissent.
that's problematic, and I don't remember the specific language of Dorch enough to answer that any better than I've tried to.
Counsel, you're into your rebuttal time if you want to continue.
If I can save some, thank you.
Counsel for appellee, whenever you're ready.
Good morning. May it please the court. My name is Christopher Mannon. I'm here on behalf of the appellee, the state of Florida. And I'll go ahead and start by addressing appellant's argument that his client was unable to fully present his testimony at his sentencing hearing. And in response to that, I have to say that the defendant was allowed to speak at length at his sentencing hearing at the point.
Counsel, we're all familiar with the transcript. Could you address the preservation issue that was raised?
Correct. So appellant's argument is that by indicating that he had more to say at his sentencing hearing, that he preserved this issue. However, to Judge Mize's point earlier, there was no legal ground stated for this type of objection, nor.
Counsel, so where that language comes from is, 9104, which says to make an objection, you gotta state the specific legal grounds. Is there a similar rule or authority that you have to state the specific legal grounds when you're trying to introduce evidence?
Not that I'm aware of, Your Honor. And because there was also no legal grounds stated.
Typically, though, isn't a proffer enough?
In certain instances, yes, Your Honor.
Hold on. If it's only certain instances, tell me when it's not, right? I think typically the case law is a proffer is sufficient to preserve evidence you're trying to get in, that's excluded. So you said in certain instances, if you think I'm wrong, which instances is it sufficient and which instances is it not?
So
Or is it just always sufficient or you misspoke?
I'm struggling to think of an instance in when it isn't sufficient at the moment.
So you agree it's always sufficient? Or at least there's no instance you can think of in which that's not sufficient?
Correct, Your Honor.
When you proffer evidence that's sufficient to preserve any legal arguments to admit it?
Correct, Your Honor. And even if the proffer in this case did somehow preserve this
Hold on.
issue,
You just said it's always sufficient. Why are you now saying even if it was somehow sufficient?
I apologize, I misspoke, Your Honor.
You said it's always sufficient, right?
Correct, Your
And
Honor.
he did it here.
Yes, Your Honor.
So was it preserved?
No, Your
Why
Honor.
not?
Because, well, as far as the transcript goes, I'm not aware of any point in which he actually did proffer this additional mitigating evidence. I mean, the judge gave him multiple opportunities to speak again, contrary to what his argument is. And time again, I can point to multiple instances in the record where after he indicated that he wanted to keep speaking, the judge allowed him multiple opportunities to offer a final word. And so,
Counsel, does counsel below have any obligation to tell the judge why the proffered evidence is relevant?
yes, Your Honor, so that they, in efforts to preserve this issue, I believe. And, but all of that aside, because the appellant entered a guilty plea in this case, the range of issues that he could have reviewed on direct appeal are limited by Florida Rule of Appellate Procedure 9.140B2A2. And because an error in the sentencing process is not.
Can rules? I guess let's just get right to Emerson then, right? So to say that the rule 9.140 limits what he can appeal presumes that that defines what he can appeal, right? As opposed to implement some higher regime. And tell us why the dissent in Emerson is wrong then. The dissent in Emerson, the way I take it is essentially the Constitution gives you certain rights. The rule can only implement those rights. It can't eliminate them, right? And so even if the rule tried to, it couldn't eliminate the right to appeal this. And by the way, it doesn't try to because otherwise provided by law, the Constitution law. And what uses the phrase law is a broad term, right? Normally, when something is referring to specifically a statute, it might say by general law or something indicating statute. It just says law. I don't think there's any definition of law that doesn't include the Constitution. So I think the point of the dissent in Emerson, which seems really compelling to me, is the Constitution gives you a certain appellate rights. The Supreme Court has recognized that. Rules can't take them away even if they try. And this one doesn't try because it says as otherwise provided by law, and the Constitution is law. Why is the dissent in Emerson not right?
So in response to that, Your Honor, I would say that the Constitution does provide the right to appeal issues at trial. However, as the Florida Supreme Court stated in Leonard v. State, there have been limitations that have been placed on that right to appeal. And I believe Judge Tannenbaum also addresses that in his dissent as well.
Yeah, he says you can limit it to being preserved errors.
Correct, Your Honor.
Yeah, so assuming it was preserved, why can't you appeal it?
Because the rule of Florida appellate procedure doesn't allow for such an appeal.
So counsel, you're not answering the question. The rule cannot change the Constitution, right? The Florida Supreme Court has said the Constitution gives you a right to appeal preserved errors. Okay? So the rule cannot change the Constitution, even if it wanted to, right? Even if that was Supreme Court's intent, which I think the dissent points out is unlikely. But then in addition to that, you have that otherwise provided by law language. So it would seem that that would encompass appeals granted by, permitted by the Constitution. So just saying 9.8 or just saying 9.140 doesn't allow this, doesn't answer the question. Why does the Constitution not allow it? What would give 9.140 the ability to override a constitutional right to appeal? And B, why does otherwise provided by law, I think it's subsection E, why does that not encompass this such that the rule isn't trying to change the Constitution or override the constitutional right?
And I think that's a very valid concern, Your Honor, and it's a great question. And unfortunately, I can't speak to that very well at the moment. I will say that
It's the key issue with the case.
correct, and that's why this issue has been certified as a question of great importance to the Florida Supreme Court so that they can hopefully provide some clarification on.
So the primary issue in the case upon which you gave us a notice of supplemental authority, you're not prepared to speak to the primary issue in the appeal and the most recent case on it that spoke to that issue that you provided to us right before the argument?
I wouldn't say that at all, Your Honor.
Counsel,
I'm not-
how would you interpret subsection E? As otherwise provided by law? What does that mean?
I would interpret that as examples where the court has provided an exception to this type of rule, whether that be through case law or statutory law.
So more than just statutory laws, otherwise provided by law would also encompass case law. Would it encompass, as Judge Mize has suggested, the Florida Constitution?
Yes, Your Honor, I would say so. And the only instance that I was able to find on subsection E in this case, or under this rule, were instances where the appellant was claiming double jeopardy. And I've never seen any other instance where an appellant who entered a guilty or no contest plea was able to appeal any other issue that isn't specifically listed under the rule. And just to, I'm sorry, go ahead.
Otherwise provided by law is listed under the rule, right?
Correct, Your Honor. However, I don't believe that that specifically allows for any type of appeal. And that's
Well, not any type of appeal, but the question is, does it allow for the appeal of a preserved sentencing process error?
I would have to say no, Your Honor,
Why?
because in this case, the appellant entered a guilty plea, and if we were to allow subsection E to encompass an error in the sentencing process in this case, then essentially subsection E renders the entire rule useless because
So why does it render the entire rule useless? It would allow for the appeal of something that occurred after the guilty plea that is preserved. It would still 9.80 or 9.140 would still foreclose appeal of anything that occurred before the plea, right? That seems like a big use to me. I don't think you could say the rule is useless because it would still allow appeals of an error that occurs after the plea.
I'm sorry, could you repeat that one more time?
So you said if the subsection E otherwise provided by law allowed appeals of a preserved sentencing process error, that would render 9.140, that section of it useless, right? That's what you said. And even if what I'm saying is I don't see how that can be correct, because even if it allowed the appeal of post-plea sentencing process errors that were preserved, it would still foreclose appeals of all issues prior to the plea. So because it would still have a huge, enormous effect, I don't see how you could say that interpretation would make the rule useless.
Well, not looking at it just in the context of this case of a sentencing process error, but potentially any type of appeal that a defendant may want to seek review of after entering a plea. And so when I say that it could render the rule useless in a sense, I don't necessarily mean only in this context, but in any context in which a defendant enters a guilty or no contest plea.
So you're saying it could allow the appeal of other sentencing process errors?
Or whatever other issue may come up.
Why would allowing, if the rule allows the appeal of sentencing process errors that occur post plea and are preserved, why does that open the door to the appeal of any possible legal errors, including pre-plea legal errors? Why is that a thing?
I would say because of the language as otherwise provided by law, it's essentially operates as potentially like a catch-all provision. And that essentially opens the door to whatever type of issue may arise after entering a plea. And I think the rule itself was implemented in efforts to alleviate the appellate courts from certain issues that can be resolved below. And as Judge Nardella mentioned earlier, in this case, while this isn't reviewable on direct appeal, there is nothing that prohibits the appellant from collaterally attacking the sentence through a 3850 motion. And there are several mechanisms that have been provided to defendants that have entered a plea of guilty to appeal errors that may occur after the entrance of their plea.
For otherwise provided by law to open the door like that, wouldn't those other, I guess, potential errors you're opening the door to have to be provided for by law?
I would say yes, Your Honor.
So if something's provided for by law, aren't you supposed to get it? Isn't that what the purpose of providing for it by law is?
Correct, Your Honor.
It seems a weird thing to say this would open the door to following the law. It seems like a weird argument.
Well, not necessarily
There's
that it,
laws that might give them right to appeal, and this would allow those laws to have effect. It seems odd.
right, and as important as the right to appeal is, again, there have been limitations placed on that. One of those limitations being the preservation requirement itself.
Council,
No, sorry.
is there another limitation besides preservation, which I think would put in the realm of like a procedural limitation, how you implement a right? What other limitations can you cite?
In this case, Your Honor, well, I would say that it's the fact that there also is no fundamental error exception to this type of issue in this case. And as you said earlier, Dortch v. State lays that out pretty clearly. And contrary to what opposing counsel said, although Dortch does specifically address a defendant who claims that they entered an involuntary plea, which is specifically listed under the rule, the court found that it wasn't reviewable under fundamental error, even because it wasn't preserved. And I find it difficult to follow that if the Supreme Court ruled that an exception or that an appeal that is reviewable after entering a guilty or no contest plea that is listed in the rule isn't subject to fundamental error. I don't see how it logically follows that they would find that an error that isn't listed under the rule is reviewable under fundamental error. Does that answer your question, Your Honor?
Well, fundamental error is tied to preservation, right? So if we were to find that subsection E only applied to errors that were preserved, wouldn't that change your analysis?
Not necessarily, because there have been instances that I've seen, such as double jeopardy, where you can have that reviewed on fundamental error regardless of whether or not.
Even when you're. No.
And even in the event that this court does find that this issue is reviewable because it was objected to and preserved, or whether this court finds that it's reviewable under fundamental error, it's the state's position that there was no error in this case because appellant was allowed to testify at length at his sentencing hearing prior to being sentenced.
how much could the court cut that off? Like, could the court say 10 minutes is enough or 20 minutes is enough? Like, is there some line of time that you would say, no, we didn't have enough time to speak his piece?
I have not found any authority that states that there is a specific allotted time. I will say that the judge notates that he had been testifying for about 30 minutes.
Yeah.
And
He's looking at 30 years, right? So that's like a minute per year.
correct. And in the transcript, you'll find the judge sort of sympathetic to the defendant because he states, I know this is a long time. And I feel it's important that when defendants are sentenced to a long time, that they have the opportunity to speak.
You know, if
However,
the judge had cut him off at 20 minutes, would that still be okay?
depending on the content of his testimony, potentially, because
How about 10?
again, I would say depending on the content of his testimony, because the issue here wasn't necessarily that he spoke for too long. It was that his testimony wasn't exactly relevant to his sentencing or to the mitigation of his sentencing. And as we discussed earlier, there was no substantial assistance agreement from the state presented here, nor was there a motion for downward departure.
Doesn't that go back to your concession earlier that you just have to put forth the evidence and that preserves all legal arguments to get in the evidence?
I'm not sure how that contradicts my point earlier, Your Honor.
My point is if all you have to do to preserve is proffer the evidence, then you don't have to give the specific legal basis that is relevant. And you conceded that earlier.
Well, I wouldn't say that proffering the evidence alone is enough to.
You said that earlier.
I apologize. I misunderstood the question. But unless there are any additional questions, I'll rely on the arguments in the brief and ask that this court affirm the trial court sentence in this case. Thank you.
Thank you, counsel. Mr. Cordell, whenever you're ready.
May it please the court. First, I want to refer to whether or not the issue was preserved. Florida Statute 9104 rulings on evidence subsection B. When the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer of proof or was apparent from the context within the questions were asked. If the court has made a definitive ruling on the record admitting or excluding evidence either at or before trial, the party need not renew an objection or offer an offer of proof to preserve a claim of error for appeal. So I believe that we preserved our issue under the statute by presenting. I don't think we had to do a proffer. We did in an abundance of caution.
Counsel,
asked-
I think what we're struggling with is the trial judge told you, in essence, that he didn't think that the proffered evidence was relevant to A, and there was no legal argument made that it was relevant to B. Is it your position that the statute doesn't require you to make to correct the judge as to why the evidence is relevant as long as you proffered it?
That is my position. And then to follow up on the question of how did the judge keep you from saying that, he left the bench. He walked off and they were going to take my client back to jail. And I said, no, we're going to offer this, or we're going to proffer this testimony. My client testified. And at the end of it, I said, I wanted to include that. This is to an empty courtroom because I think it would have been relevant for the judge's consideration in sentencing. I made the argument and the judge just wasn't on the bench.
I think the ruling, the evidence that the language is most compelling of that is it says a court may predicate error and grant new trial, set aside a reverse of judgment for excluding evidence when the substance of the evidence was made known to the court. I think what you're saying is maybe it would be more fair to the trial judge if he or she was entitled to the legal argument, but the statute doesn't say you have to do that.
That would be my position. That's always how I've known to
Yeah.
preserve things is if there's any doubt, proffer it, you've preserved it. I was trying to do everything I could.
Because what you're saying is, well, you didn't do everything you could.
I was trying.
All right,
I didn't say relevant until he left the bench.
Correct. But you didn't say what it was relevant to.
Yes.
All right. So you didn't do everything you could in
Right.
fairness. But I think what your best argument is maybe it wasn't fair to the trial judge, but the statute says I don't have to be fair to the trial judge. There's no rule that statutes have to be fair to trial judges.
I agree with that. And I did say at my page 71 of the sentencing transcript after testimony, I said I wanted to include that because I think it would have been relevant for the judge's consideration in sentencing. I didn't say it was about specifically substantial assistance. I said it was relevant for sentencing. It's mitigation. I direct the court to the language in Ventura where the opportunity to address the court is important, even involving a mandatory minimum. Quote, respecting the right of the defendant to address the court maximizes perceived equity of the process, citing the ABA. I think it's really important that a defendant be allowed to fully address the court.
All right, counsel, you're out of time.
Understood.
What-
Thank you. Your
Before
Honor.
you leave, are there any other questions?
Thank you.
Court is adjourned.